Hello and welcome to IP for Startups, a monthly series. I'm Julie Cranston, Director of the SBDC at UCIBL Applied Innovation, and I'd like to thank you so much for joining us today. Today's webinar is brought to you by the SBDC at UCIBL Applied Innovation in partnership with Troutman Pepper. The SBDC is funded in part by the U.S. Small Business Administration and the state of California. The SBDC is here to help you start, grow, and succeed in your business by providing no-cost expert consulting and training such as this webinar. In addition to our regular no-cost consulting on business management and funding, we also have been helping our small business clients deal with business challenges related to COVID. We have a hotline set up and additional resources available. If you need additional assistance during this time, please get in touch with us to see how we might be able to help, all at no cost. Our hotline number is 1-800-616-7232. If you're a tech or life science business, you can go straight to our intake form at sbdctech.org/contact. And we have a COVID-19 resource guide available at ociesmallbusiness.org. We'll put all of this information in the chat feature. A little housekeeping before we begin. Everyone is muted during the webinar. Tomorrow, the recorded webinar and a PDF copy of the slides will be sent to all participants. There will be Q&A throughout the presentation, so please feel free to ask questions during the webinar by clicking on the Q&A box at the bottom of your screen. We may not get to everyone's questions, but we will do our best. If we don't get to your questions, please email hkhaled@fullerton.edu and we will attempt to answer them and get back to you. Our program today will be presented by Stephen Kong, partner at Troutman Pepper. Stephen focuses his practice on technology and intellectual property transactions, including intellectual property licensing, technology development, and transfers of ownership and commercialization of content and media. He has particular expertise with software, internet, and information technology matters. He spent the vast majority of his career practicing in Silicon Valley and continues to advise on these transactions. Stephen has extensive experience managing the intellectual property aspects of mergers and acquisitions deals. His clients include private equity firms and companies in a variety of industries, including software, e-commerce, consumer electronics, retail, and apparel. He previously served as senior corporate counsel for Sony Computer Entertainment America, or Sony PlayStation, in-house counsel for a major mobile gaming company, and general counsel of an augmented reality hardware and software developer. He also worked in software development as a civilian for the U.S. Marine Corps before attending law school. Stephen, thank you so much for being here today. I will now turn the program over to you. Stephen, I think you're muted.
Here we go. I think I'm unmuted now.
Yep, can hear you great. Thanks so much.
Great. Hey, I'm glad to be here. I wanted to just emphasize one thing that Julie had mentioned, which is I really want questions to come in the flow of the presentation. So I've given a lot of presentations in my career. Admittedly, this is the very first time doing it through Zoom, but I've always found that questions as I'm presenting seem to go better for both me, the question asker, and all of the participants. And there's really no reason to wait till the end. I've prepared some slides, but the reality is that I want to view this hour as an opportunity for people to ask the kinds of questions that frankly are not easily found in the zillions of pages of reference materials that are out there about licensing. There are, I prepared 21 slides, and the reality is that you're not going to be able to cover licensing in an hour. I mean, you're not even going to be able to cover a small sliver of licensing in an hour. So what I've tried to do is I've tried to give all of us basically a few fundamental frameworks to help guide move the conversation along a little bit, but really it's going to be much better if I hear what you guys have to say. So my next slide just talks a little bit about myself. Julie mentioned it. I am both what I would call a day-to-day licensing lawyer, meaning I deal with companies who are both what we call inbound licensing technology. So we'll get a little bit of vocabulary out of the way. Inbound licensing technology means you are taking in the license. You are the licensee. You need some software in order to help run your business. You need some content. You need some pictures. That's an inbound licensor. An inbound licensee. Then I also work with companies who commercialize their products. And so that's what a lot of times you call an outbound licensor. So, typically that would be like a software company. Software companies make their money granting license rights in their software. So they are engaging in the outbound licensing of their intellectual property. So I do a lot of work in day to day, but I also, and I think in a lot of ways, this next area of my practice is probably going to be of more interest, I think, to a lot of people. I am what's called an IP specialist in mergers and acquisitions. And what that means is I represent buyers and sellers in the IP aspects of M&A deals. I work on the diligence and I work on the actual deal document that deals with the risks. If you're the buyer, hey, what kind of IP risk am I taking on when I buy that company? When I represent the seller, hey, how do I respond to the buyer's concerns about whether there's IP risk? And so, one of the big takeaways I wanted people to get out of today's presentation is that, a lot of times the licensing issues that we work on day to day, you should always be thinking about it from the perspective of like, boy, hey, am I getting all this taken care of for the day when I want to exit, for the day when I want to sell my company? Is there anything that I've done in my licensing practices that's going to cause a potential buyer to have concerns? So that said, let me talk briefly about what we're going to cover. Okay, we're going to cover 4 main topics today. We are going to cover exclusivity as the basis of IP licensing. That is the whole fundamental concept of licensing. I never take anything for granted. I've told people I'm a licensing lawyer, and they always think that it means I help people obtain regulatory licenses, a hunting license, a fishing license, a driver's license. No, it's not. It's not that. When we talk about licensing, we're talking about someone owning an exclusive right in IP and letting someone else exercise that right. So when we keep in mind that exclusivity is the basis of IP licensing, a lot of things flow from that fundamental understanding. So if exclusivity is the basis, what are the exclusive rights in copyrights, trademarks, and patents? So I'll cover that next. That tends to overlap a little bit with probably past presentations you may have heard about, what is IP and things like that. So there'll be a little overlap there. Then what we're going to do is we're going to flow into a real world example of software distribution license. I chose that example because it lets us see a lot of the typical commercial issues that you deal with when negotiating a license. And I think it's something that people can kind of get their hands around. And then lastly, I talk about, hey, what are the kinds of things that I would see when I represent a buyer or seller? What are the things I've seen in my career that have been problematic when a company's looking to sell itself? So let's see. I got to admit, I thought I saw that there were 2 questions already, but that can't be, is it? Hannah, I'm going to reach out to you, just make sure that's the case.
Yes,
or not the case.
There are a couple questions that started right before you even started your presentation.
Well, I tell you what, I'll ask you to take a quick look at them, and if it makes sense to address them now, I'll do it. Otherwise, I'll just keep going.
It is about patent licensing for SBR grants. Do you feel like that is relevant to discuss now?
Not quite yet. I've already broken my cardinal rule, which is to say, I do generally want the questions, but I tell you what, if we can just kind of hold that one till we get a little bit further, and then maybe we can revisit it. So, okay, so great. So the exclusive rights licensing means obtaining a right exclusively reserved for the IP owner. So let's go ahead and talk a little bit about that. Let's talk about copyright really quick. So when someone owns a copyright, they control the exclusive rights to reproduce, prepare derivative works, distribute, perform publicly, display publicly, and perform via digital audio transmission. For the most part, let's just focus on those first 3, the exclusive right to reproduce, the exclusive right to modify, and the exclusive right to distribute. So keep in mind one thing, and this is going to be very helpful. If you think of software as no different than any other type of written work, then you are more than halfway, I would say, to understanding how software licensing works. So just keep that in mind. Software for purposes of the law is treated no differently than, say, a magazine article. If you want others to be able to take your software and distribute it, it would be kind of no different than someone giving someone else the right to distribute their article or their photograph. Let's talk briefly about trademark exclusive rights. So trademark owners control the exclusive rights in their brands, marks, or their identifiers. I think we're going to see in our example that it dovetails nicely with our example of software. And then patents. Patents is one people like to focus on. I want to talk a little bit about what a patent exclusive right is, because it's a little bit fundamentally different than some of the other rights. So,
question. Sorry to interrupt.
Yeah, go ahead. Yeah, of course.
Does including the C for copyright next to the company name on every page of every document help to protect the IP?
Well, I think what it does is it technically helps to put the world on notice that that page is copyrighted. But the reality is, in copyright, you get the rights in the copyright the moment that you have created the written work. So the lawyerly words are fixed in a tangible medium of expression. So the reason why people put copyright notices is you're trying to put the world on notice. Hey, this is mine. But the reality is the copyright existed the moment it was made. So I don't know if any of you guys are YouTube users, avid YouTube users. I am. I love going on YouTube. I don't know if anyone here has ever seen when people put on the YouTube that they don't claim copyright ownership, that they somehow like putting those magic words. That also has essentially no effect. So I'll take one follow-up question. There was a question about the importance and the validity of the year on the copyright notice. To be honest, it's not that critical. People like to put it sometimes because they try to emphasize how recently something was done. So a lot of times I think people really tend to put it on there because they're trying to say, hey, listen, I just created this. And you're almost trying to advertise like how maybe up to date the materials are, but really the year isn't that super critical. You want it to be accurate, but it's not really that critical. So then I think that there was a question, I think it may have been deleted, about the trademark notice. I can't remember, I don't see it now, but I think that it's, I'll tell you what, if I remember it correctly, it was basically, well, what's the gist of, what's the importance of putting the trademark notice? Again, you're trying to put people on notice. It's really, really difficult to go after people after the fact, right? So a lot of times the whole point of these notices, and we'll actually get to these notices later on, is that you're trying to prevent the infringement in the first place. And so again, everything that you can reasonably do to put the world on notice, that's great. So let me go on here about this patent exclusive rights. So the one thing that's a little bit different about patent exclusive rights is that the patent owner has the right to exclude others from making, using, or selling. That's a little different. That's a very key distinction. And I don't know if it's ever come up when people listen to presentations on patents, but remember, in the copyright example, the copyright owner has the exclusive right to do something, right? They have the exclusive right to do the reproduction. They have the exclusive right to do the distribution. Here, you don't have the exclusive right to make, use, or sell. You have the exclusive right to exclude others. Now, I have to admit, that's kind of a tricky concept. It took me a while, actually, even as a lawyer, to figure out, like, what the heck does this really mean? And, it's funny, I've come across an example that I think is hopefully going to be helpful. Think about if someone came up with a patent for a stool, and they said, okay, a round seating surface with 3 legs. Okay, that's what a lot of stools look like. And then someone else comes along and says, you know what, that's, I think I've got a better idea for a stool. Let's make it a round seating surface, but let's add a fourth leg. Well, if you got a patent for that, you would have the right to exclude others from making that stool with the 4 legs. But that doesn't mean you can make it, because, you know, somebody already has the patent for making a round seating surface with 3 legs. So I always try to go back to that example. You can exclude someone from doing the stool with the 4 legs, but you don't necessarily have the right to make the stool with the 4 legs yourself, because someone's got that patent for the stool with the 3 legs. So hopefully that's a relatively simple example. Let's see here. We've got a question from Jessica. She says, should you use a letter of intent before negotiating the exclusive licensing agreement? Okay, well, that's a couple of interesting things. I'm not sure whether the exclusive really matters or not. I think the gist of the question is, should you use a letter of intent before negotiating the exclusive licensing agreement? Well, let me talk a little bit about what letters of intent generally are used for. Letters of intent generally don't really have any legal effect. So you ask yourself, well, then why do it? Well, there's a couple of things that, in my experience, goes on when letters of intent are introduced into the process. I am not going to lie. It can take a really long time to negotiate a license. There's lots to negotiate. There's lots of pitfalls. Sometimes people feel that that if parties enter into a letter of intent, that it helps get the negotiations going a little faster, because you try to agree on sort of the big picture points. A lot of times that's what's going on. You know, to be perfectly honest, a lot of times it's used to try and show potential investors that, hey, I'm in some real serious talks with XYZ company. But, you know, there's no actual legal reason why you have to have a letter of intent. They generally are of no legal effect. You know, sometimes people will use it as a way to put in a confidentiality provision, because as part of the negotiation process, a lot of times there's going to be some exchange of confidential information. But you don't need a letter of intent for that. You can have just a regular old, confidentiality agreement. So tell you what, I've gotten some questions that have come in. I'm going to try to put off some of the ones that I think are a little bit more IP specific as opposed to IP licensing specific, because I do want to make sure to hit some of the licensing provisions. So what I'm going to do, just to let people know, is I'm going to try to focus on answering the questions that are a little bit more specific to licensing. So that said, but I will try to hit all the questions before it's over. So we've talked about all the exclusive rights. Now let's use one real life example to hopefully kind of put it all together. So the example I like to use is software licensing distribution. Okay, so again, quick recap. We treat software like it's a literary work. So what happens when software is distributed? You have a literary work that's distributed. What happens when someone's running software? Well, when software is run, you know, when software is loaded up in a computer and it's being run, technically what's happening is that code, you know, the language, the code, you know, in this case, the object code is actually technically being copied. You're creating a copy of it in memory. So under the law, we say, hey, you can't run a piece of software without creating a copy of the software, which is why the owner of the copyright in the software gets to control who runs the software. And that's why you need a license in order to run software. And a lot of times when someone else takes software and they want to distribute it, they actually have to make slight modifications to it, right? So imagine like, this isn't really what's going on, but a lot of times, let's say Adobe Acrobat, which is the example we're going to use in the next slide or so. Let's say that the original version of Adobe Acrobat only ran on Windows. And Apple said, you know what? I really want people, when they're using their Mac, to be able to read Acrobat files. Well, Apple might say, hey, listen, I'd really like to modify that software so that it works really well with the Mac OS. And so that would be an example. Again, the owner of the copyright gets to control whether it's modified. So if Apple wanted to make those modifications, they would need a license in the Acrobat software. So let's see here. I'm just going to read through the questions really quick to see if we've got one that I think is good for licensing. Otherwise, we'll have records of them and I'll try to have to hit them afterwards. Well, I tell you what, I see a question from Xander about software licensing. Xander, I'm going to try and run through my example really quick, and then I'll try and get back to this. So here's the other thing about software licensing that is relevant to the example I'm going to come up with. I've been talking a lot about how software is covered by copyright. Keep in mind that software may also be covered by patent. So there may be patents that cover the software. And then the other thing that's important is that software is often associated with famous brands. So I keep coming back to this Acrobat example. Windows is another example. And so if you wanted to distribute software, a lot of times there's a lot of benefit that comes from leveraging the brand, right? So if I'm Apple and I want Acrobat to be a copy of Acrobat to come preloaded with each version of Mac OS, hey, I want to tout that to the world that, hey, Acrobat Reader comes preloaded and I want to be able to use, Acrobat, a trade name, Adobe Acrobat, things like that. So when you are obtaining rights to distribute software, a lot of times there will be copyright for sure. That's a given because the code is covered by copyright, but there may be patent if the software is covered by patent. And if the software is famous, you may want a trademark license. So let's see here. So here's the factual background that I've been kind of leading up to. A hardware company wants to include software within each, sorry about that. Within each of its products. The one I've been running up to, hardware preloaded with Adobe Acrobat. Let's go ahead and just run with this Apple example. That's an easy one. Maybe Acrobat needs to be slightly optimized. Apple knows its hardware better than anyone else. And so Apple says, hey, listen, I know, here's a more realistic scenario. Adobe's not dumb. They want Apple users to be able to read Acrobat files. But Apple says, hey, you know what, though? We're the ones working on the latest versions of Mac OS. We're in an even better position to optimize how Acrobat works on our OS. And so Apple might say, hey, I want to make the modifications myself. So that's a real world example of where all those different copyright rights come into play. And if I'm Apple, I need a right to distribute, right? Because there's going to be multiple versions multiple Mac OSs going out there with this. I need to be able to reproduce, right? Because I need, again, it's going out on, tens of thousands. Well, I obviously need to make tens of thousands of copies. And then I need this right of modification. And by the way, just keep something in mind. I've been talking about the situation with Apple, representing Apple as the inbound licensee. So remember, we talked about that early on, the inbound licensee. Well, that means by definition, Adobe is the outbound licensor. For our example, we're going to keep it simple. We're going to assume that Adobe created and owned all the IP in Acrobat. And that because Adobe owned and created all the IP, they are the ones who are the only ones who need to give this permission to Apple. Keep in mind in real life, that's not the case. Even a company as big as Adobe's got third-party software within Acrobat. You can look it up. There's all kinds of open source software that's within Acrobat. And so in real life, Adobe would then, even if they struck this deal with Apple, Adobe would then have to make sure that it has its rights from its licensors. So this is why licensing is so interesting, because for the most part, and I'll come to this example in a little bit, everyone's an inbound licensee a lot of times and an outbound licensor. And so even the ones who license out, a lot of times what they're licensing out contains things that they licensed in the first place. And a lot of the reason why the most common type of lawyer in Silicon Valley is the technology transactions lawyer. It's actually not the corporate lawyer. It's not the litigator. Within the world of technology law, by far, the largest number of lawyers by type are licensing or tech transactions lawyers because of basically just having to keep track of all this sort of thing. The other thing to keep in mind too, we always talk about licensing as if it's, you know, for technology, but basically an entertainment lawyer in LA is a licensing lawyer. If you think about it, what are they doing? What are movie studios doing? They're taking books, they're taking plays. They want to be able to create derivative works. Remember we talked about that. When you take a play and you want to turn it into a movie, when you take a book and you want to turn it into a movie, what are you doing? You're obtaining a license from the owner of the book. And you're saying to the owner of the book, hey, I'd really like to create a screenplay out of this. Well, remember, the owner controls the exclusive rights in that. So whenever someone says, I'm an entertainment lawyer, there's a really good chance they're really a licensing lawyer. And then once the studio makes the movie out of the book, well, what does the studio want to do? Well, the studio needs to be able to distribute it. Studio wants to be able to commercialize it themselves. So the studio might say, hey, maybe someone wants to make a game out of this and have a tie-in with the movie. At that point, depending upon what the studio was able to negotiate with the book writer, they may or may not control those rights. And so really it's just a big game of like allocating, creating, and licensing all these rights and trying to keep track of who has rights and what. Bottom line though, super, super valuable. So let me just double check to make sure we haven't had some new questions come in. Tell you what, Xander, I don't think we've had yet, but I will keep going for now. So we've talked a little bit about this, so I'm not going to belabor it, but you know, we know Adobe owns the copyright and the code. So we know that Apple needs rights. We've talked about this a little bit. They need to be able to reproduce. They need to be able to distribute. They need to be able to modify. And they need to be able to even run the code for testing. You know, we've got the fact that Adobe owns a trademark in Acrobat. And Apple wants to be able to have a license to be able to tell the world, hey, it comes preloaded with Acrobat. And Acrobat's the term by which everyone knows what the software does, right? I mean, Apple could go around saying, hey, it comes preloaded with Adobe's image viewing software. Is that as good as saying that image viewing software, or do you want to say Acrobat? You want to say Acrobat. So you want to make sure to obtain a trademark license. So at this point, we've sort of focused on the what. You know, what has to be licensed, these rights to reproduce, these rights to distribute, these rights to modify. Okay, so what else has to be negotiated? Well, you know, you still got a whole bunch of these basic commercial terms around the what. How about the where? You know, I'm Apple. Do I get to distribute Acrobat everywhere in the world? Maybe just in some countries. You know, this is where you know, tends to be a lot of negotiations. When? How long is the license going to last? You know, is it exclusive? You know, I think I'm not going to insult anyone's intelligence. I don't think Adobe would ever, given how many people run Windows, I don't think they're ever going to give Apple any exclusive rights, but there's all kinds of stuff that is licensed exclusively. It comes up a lot in the gaming world. Yeah, I used to work in-house at Sony PlayStation, and the way that Sony PlayStation competes a lot with Xbox is they try to see who's got exclusive titles, right? So exclusivity matters a lot for some types of software. And then of course, the how much. Well, the how much is not that simple either, right? If you're Adobe, you know, do you want to be paid something per year, you know, or do you want to share in the upside, so to speak? You know, if Apple has a really good year and they sell a lot of copies or they sell a lot of MacBooks that have Mac OS on it, you know, do you want to share in the upside? Do you want it to be a per copy type thing? So, you know, there's a lot that needs to be worked out. Then let's talk a little bit. I'll tell you what, this is actually kind of a good time to stop. I'll try and take a couple of these questions. Let's see. There was a question from Xander who says, if my company created software, is it better to license to a trade entity that I own for signing business agreements with customers? Well, I will say this, Xander. I think what you're really talking about is you are talking about, that's more of a tax question. So I think what you're getting at, and hopefully Xander maybe can reply to this, so I see if I've got the gist of it. You will hear these things about how, big companies out there, your HPs, your IBMs, that they'll create these licensing entities that are maybe set up in Ireland. And there's some reasons why you transfer the software over to this entity and, for various tax reasons. I fully admit, I'm definitely not a tax lawyer. So I'm going to punt a little bit on that one. Then we've got a question from Sam, who says, what are some key differences between software and hardware IP license? We've been approached by a company in Asia to have, for exclusive manufacturing and sales. They want to rebrand with different model name. Well, okay. That's a pretty broad question, but I think that's kind of ripe for addressing a few things. Well, one key difference between a software and a hardware license is that software for sure will involve a copyright license, because under the law, we treat the code of software, the object code, the thing that's really running, both the source code, which leads the object code, but we treat that all no different than any literary work. We treat that if for those of you who've written software, you can do a source code listing. We treat that no differently than if I were to sit down and write a great novel or something. So it's very much handled by copyright. Now, hardware is different in the sense that there may or there may not be a literary work. A lot of times with hardware, don't forget, there's still firmware a lot of times, and we treat firmware just like software. But if what you mean by, and I think for this crowd, I think there's a really good chance when we're talking about hardware, we're probably talking about something that's got firmware, maybe it's got chips in it. A lot of times the IP with chips is covered by copyright. I mean, in theory, of course, hardware could literally mean like, a crane or something like that, in which case what would be being licensed would probably be a patent. So that would be one of the key differences. Software in theory can involve a license of copyrights, trademarks, and patents. But in my vast experience, it's for the most part a copyright and a trademark license. Hardware, similarly, it can be all three things also, but it tends to lean more towards patent and trademark also. So hopefully, Sam, that answers your question. Let's see. Okay, so I am going to talk about something that's very critical, I think, in our software distribution example. Now, remember, for those of who may have been coming in the middle, but it's also just a good reminder, what is the factual scenario we're talking about? We're talking about a hardware company, or I'll call them a hardware company, Apple, who's got Macs that they want to preload with Adobe Acrobat software. Okay, well, what can go wrong? Okay, risk allocation is one of the most important things about a license agreement. Well, what can go wrong? Okay, the software can perform badly. Okay, so that's what we call performance problem. There can be an infringement problem caused by the software. And what we mean by infringement is we mean IP infringement. It could be that the software code that Adobe says that they owned, it turns out they don't own. Okay, I mean, by the way, little lawyerly disclaimer here, these are all made up facts, okay? I am not implying that Adobe has any sort of infringement problem with its software. So that's the second major issue. Third one that was not nearly as big, even 10 years ago, certainly not 20 plus years ago when I was cutting my teeth, is issues with data privacy and data security. Anytime a hardware company introduces third-party software into its environment, you run the risk that the third-party software opens up security problems. You introduce the risk that the third-party software collects data from users and misuses that data. So those are fundamentally the three things. Now, if you think about it, right, you talk about risk allocation, all of these three things suffer from, when it comes time to figuring out who's going to be responsible for it between Adobe and Apple, they all suffer from the same fundamental problem, which is, the reality is all three of these problems could be caused by either the hardware or the software, or a combination of both. And that's where the negotiation and the language that you put in the license agreement is tough. So let's talk about a simple example. Let me see if I cover this in my next slide. Let's talk about infringement. It could be that the code, the simplest example, kind of on, we've got two ends of the spectrum. The simplest example where it's just Adobe's fault is that it turns out that they took the code from someone. They simply ripped it off from somewhere. And this person starts to find out that, like, hey, wait a minute, all this code, all my Acrobat code that I wrote is sitting on a bunch of these Apple machines. That's a simple example of where, hey, only Adobe's at fault. To the extent Apple gets sued, Apple should be able to, in sort of a fair world, say to Adobe, hey, what's going on here? I distributed a bunch of your Acrobat software on all my machines. I'm getting sued like crazy by this developer. And, I didn't write the code. I didn't test the code. I took it from you. You're responsible. That's a simple one. And here's the far end of the spectrum. The far end, where it's only Apple's fault, is Adobe says, hey, I have this code and I get the right to control how it's distributed, but only in North America. I have an agreement with one of my third-party developers that he's going to control the code in Europe. So in North America, I have all these rights. And if the license were done correctly, Adobe would say, hey, listen, you get to preload these copies of Acrobat on all the machines that you distribute in North America. And it turns out that Apple doesn't do a good job, say, for example, of controlling which machines have the code. And so some of the machines that come preloaded with Acrobat are in Europe. That's the far end of the spectrum. That's only Apple's fault. If Apple had just stayed within the bounds of its license, then Adobe wouldn't be in trouble, and and Apple wouldn't be in trouble. There's a whole bunch of that's kind of in the middle, So let's say, for example, let's take that example where Apple said, hey, listen, I want to modify the software. And because I know my Mac OS better than you do, and let me modify it, and it'll run better. Now, and this is why these infringement lawsuits can take a long time, but maybe Apple modified it in a way that, but for Apple's modification, there wouldn't have been infringement. Maybe Apple modified it in a way that now the software runs afoul of a patent that someone's got out there. Or maybe Apple, when it did its modifications, took some software that someone wrote, and Apple didn't have a right to it. This is why all the risk allocation language in a license has to be, really well thought out, because you're trying to think about all these scenarios in which one party should clearly be at fault, or is clearly at fault and should be responsible. You've got ones where the other party is clearly at fault, should be responsible. You're trying to allocate what happens in between. So let's see here. Tell you what, let's see. Let me take a couple of questions here. Let's see here. Gray Cash writes, sorry, I hope you don't mind. I don't think you're going to care. I'll say I have an implied license to say your name, since I think everyone can see it anyways. If you were looking to license your IP, how would you go about finding a company that wants to make use of it? That's a good question. I would say, frankly, that's more of a business development type question. There's people who specialize in this sort of thing. Not an easy question. Gray, I'll probably, if you don't mind, I'm going to hold that one. Maybe that one I may have to try and address offline. Let's see here. I've got some questions that are along the lines of they've got some, there might be a dispute. Let me hold off on that while I try and hit some slides. For everything I don't get a chance to address here, I'm going to try. I think I should after, hopefully Hannah can confirm, we will have these. And so I should be able to address them after. So let's keep going on this. We've talked about some of the issues with allocating risk. Now let's take the infringement example. A lot of times the licensee will say, hey, if it turns out there's an infringement issue, so I'm Apple, right? I'm the licensee. I'm the one bringing in the Adobe software. They might say, hey, listen, if there's an infringement issue, I either have the right to require that you replace it or that you fix it, or that I get to terminate and I get a refund. That's very typical that a licensee will negotiate that. And if you think about it from a licensee's perspective, that's really a pro-licensee type of provision. You know, they get to control the remedy. From a licensor standpoint, you have to ask yourself whether this is necessarily what's best for you. Because, for example, let's say that Apple says, hey, listen, I think that there's an infringement issue here, and I don't think you can fix it to my satisfaction. So therefore, I'm just going to take a termination right. And I'll take a refund for the amounts I prepaid in advance. Let's assume that there was some prepayment. Well, if you're Adobe, ask yourself, hey, you know what? Is Apple just sort of having a little bit of buyer's remorse here, and they're just sort of ginning up this issue? Yeah, maybe there is a IP infringement issue, but it's very easy for me just to update my software. So moving forward, this isn't an issue anymore. Why should Apple have the full rights to just choose the remedy? So this is again, this hour is not enough time to talk about like all the different dynamics, but I just want to give people a flavor of like, how nuanced the negotiations might be in terms of allocating risk. So we've talked about this remedying infringement, licensee versus licensor concerns. Basically, do you have a situation where one party has a little bit too much control over how to remedy the infringement? So now let's talk a little bit about, because we've all, I think, on here have got some issues about, or not issues, but aspirations, I should say, about exiting. So again, now I'm going to put on my hat as the lawyer who tends to counsel the companies who are either buying startups or I'm counseling the startup who wants to be sold to. So there's let me assure you one thing. Very few things get diligenced as carefully as your licensing arrangements, because a buyer is always very, very concerned that they're buying a company that either didn't license all the IP rights that they should have, or that when they granted the licenses in their own IP, so when the startup acted as the outbound licensor, that they didn't do a good job. So let me assure you, fortunately for me, I mean, this makes for good job security, but nothing is as reviewed as extensively as these licensing arrangements. So I'll tell one anecdotal story. I once worked on a deal representing a buyer, and this company basically did, they took data from its customers, and they did things. They did a lot of data analysis. You're going to see that a lot. I mean, frankly, that's basically Facebook's model of why Facebook's a multi-billion-dollar company. And the CEO was very proud. CEO was very proud that they kept legal costs down over the years. And I want to say they spent a very, very small, I can't quite remember the exact amount, very, very small. And we were like, wow, how did you keep your legal costs down all these years? Well, I negotiated my contracts myself. Well, turns out that they didn't get the rights. Remember, right? Inbound licensing, you're always trying to make sure you have all the rights you need in order to run the business. They didn't get all the rights they needed. At that point, there were thousands and thousands of customers that they were using their data from. And it was going to be problematic to go back at this point. It's like anything in life, right? If you try and get the rights afterwards, years down the road, well, most IP owners or content owners ask themselves, why are they approaching me now about these rights? And, and tend to go up. And so the bottom line is these are some of the hardest problems to fix after the fact. So just keep in mind, the typical startup will deal with these types of licensing arrangements: the inbound IP, okay, the software that they use, or even more seriously, the software that they distribute. That tends to have even more issues. Obviously, every startup out there licenses lots of IP. I don't think they think of it that way, but for everyone out there who uses Windows and who uses Acrobat and who uses PowerPoint and things like that, you are a licensee. Now, when I represent a buyer, we're not particularly concerned about that kind of IP being licensed, but we are concerned if you take software and then you say, hey, I've got a great IoT device, Internet of Things device, and there's some software that goes on every one of these. If I were representing Ring or something like that, every Ring device has some software. Those types of inbound IP we're very interested in. You've got your direct customer licenses, particularly if you are a software company. You've got your distribution arrangements, and then you've got your straight outbound IP. That's a little more rare. That's literally like a startup that's got a patent and say they want to, I'm going to address, there was a question from Jay, I think, what are the risks involved with pharma licensing? Well, that's a little bit definitely beyond that, but Jay, I'm going to address this after the call, because you could do a whole hour on like pharma licensing, but pharma licensing does tend to be patent heavy. There can be issues of like software because, like bioinformatics, but, for the most part, you are dealing with licensing out patents. So now, what are the problems with the IP, inbound IP licenses that buyers are concerned about? Well, again, I keep hammering the same point, but it's really the same point over and over. Do you have all the rights that are needed? If you're Apple and you take this software and you distribute it around the world with each of your machines, did you get a worldwide license? I know some of this sounds so basic, but these are the kinds of things that we see. Did you maybe you unilaterally modified it? Maybe you unilaterally said, what, this software is going to run better if I include these libraries with it. Well, you probably need a license in order to do that. Did you obtain that license? I'm going to talk a little bit about, we talked a lot about this inbound software, so I'm going to skip that right now. But I do want to, on this slide, I do want to talk about a couple of things. Most people don't realize this, but anytime you use your Facebook and your Instagram, your TikTok, I use Facebook because Facebook's the one I use the most. I don't think most people realize that every user of Facebook is a content licensor. Okay, we don't think of ourselves that way, but every picture that you post, every little story that you write, you own the IP in that. Facebook, when you read the terms, Facebook very clearly says they try to not use a lot of legalese, but at the end of the day, Facebook is an inbound licensee. Facebook is licenses zillions and zillions of bytes of data from millions of users. We're all licensors to Facebook. So if someone wanted to sell Facebook, one of the things that would be really, really scrutinized would be the license agreements that, yes, I don't think we've all thought about it, but we have all entered into licensing arrangements with Facebook. Any one of us who has a Facebook account, we are licensors. It's all in there. You can check it out. So let's see here. Let's see here. We've now let's talk a little bit about outbound licenses. I think we've all hit it a lot here in this example today about enterprise software. That's the typical one. Anybody here? I used to do a lot of work for various what I'd call connector type clients. People who want to put together, basically eBay, right? If you think about it, eBay is taking content from people and making sure that that content gets displayed to others. And so, one of the things I always want to flag for people in something like this is that, a lot of businesses out there, you're both a licensee and a licensor. But a lot of times people haven't bothered. Your terms of use for any sort of web-based business should have lots of licensing provisions in there. A lot of them don't. I'm always a little surprised. I'll click on some of these terms of use and I'll be like, hey, where's all the provisions that deal with all these things that the company is doing? Even something as basic as like, hey, I want to connect pet owners with pet sitters. What kind of licensing is involved? Yeah, probably not a ton, but some. The pet owner wants to be able to upload a photo of the dog or the cat. They want to be able to put information. Maybe part of your job as the company who's finding pet sitters is that you say to the pet owners, hey, we have pet sitters who come on to our platform to look for gigs, but maybe it makes sense that you want to use other platforms to try and find these. Maybe you go on LinkedIn, maybe you go on Craigslist. Well, at that point, you need rights in order for that photo to be able to then put it onto these other platforms. And a lot of times people haven't really thought through this. So let's see, at this point, I think we're running close to the hour. So I want to try and go back at this point and try and hit some of these questions. Let's see here. There's a question from Mike Robinson who says, I'm trying to scale my company. I don't want a franchise, but instead create new separate companies with trusted partners I know. Okay, yep, you see that model. I'm hoping to license my existing software and branding and name to license to new partners. What sort of things should I watch out for in trying to create revenue streams off these items? Well, that's a good question. Hopefully Mike Robinson, I hope he's still listening, because I'd love to know a little bit more factually, because I feel like this could actually be a good set of a good factual scenario of which to answer some of these questions. But when you say you hope to license your existing software, what exactly does that software do? Because I think I'll be able to answer that question a lot better if I get a little bit more detail about what that software does. In fact, gosh, I don't know. I'm going to ask Hannah. Is it possible, Hannah, that Mike Robinson actually get on and talk in real time? Or is that too difficult?
No, it's totally easy. However, he has left the building. So.
Okay. Sorry. Let me take another one here. There's a question. Well, I'll tell you what, there's a question from Methode. Sorry. Oh, wait, was it from Methode? Shoot. Well, there's actually one from Anonymous. When I post a picture or text on social media like Facebook, is it better to have a copyright mark on the post? It's not necessary. It's actually not necessary. If you want to do it, that's great. If you think that it helps dissuade others, your rights are no more expanded really in that context, but I don't really see the harm. Let's see here. When I share someone else's post on my Facebook page, do I violate any IP right? Well, that's actually a good question, because the answer, I believe, is no. And I'll tell you why. It's because that when one posts content on Facebook, they give Facebook the right to allow others to repost. So that's a good example of where Facebook is both bringing in rights and granting out rights. But again, you theoretically control all that, because when you sign up for your Facebook account, you tell Facebook, hey, when I post this content, I'm giving Facebook permission to allow others to do certain things with that. And so, reposts and things like that, I believe are permitted. But if Facebook didn't obtain those rights, the users would not be able to repost it. So let's see, let's try and take a few more questions. Jenny Jefferson, let's see, is Jenny, Hannah, is Jenny still on? Do you know? Can you tell?
She is.
Okay, so hopefully Jenny can hear this. Is copyright necessary for a staffing agency? I'm not quite sure I understand the question, but I feel like it's got potential. So I'm hoping Jenny can get on and maybe ask it in real time.
Yeah, Jenny, you have ability to speak. You just have to unmute yourself.
Hello, good afternoon.
Hi.
I own a staffing agency. I'm barely starting. So my question is, would I need like copyrights for not the software, because right now I'm using a third-party software company, but say for my business logo or contracts, is that something that I would need?
Well, your business logo, you would definitely want trademark rights in it for sure. So your logo, I think of that's more of like a trademark issue. I think what you're asking for the staffing agency, so you have a staffing agency, which probably supplies like short-term workers to other companies. I think that's what you're saying.
Correct.
Okay.
Correct.
I think, and what do these workers do? Do they do software development? Do they do accounting? What do they do?
Well, here, let me tell you a little bit about the company. So we staff former inmates. Our company, basically, we focus only on former inmates, people coming out of prison. So they work in several jobs. Construction, warehousing, accounting, some do administration, depending on their skills and what they can do and what the client is looking for.
Okay. So I think the question is, I think to try to answer the gist of your question, I don't think a lot of what your business relies upon is the actual IP. In other words, you're supplying the labor, but you're not really saying like, hey, and this labor, by the way, uses my company's like proprietary methods or proprietary content. Now, if I'm wrong, that would change my answer quite a bit. But, so for example, when I was a kid years ago, I'm going to age myself a little bit. There was Kelly Staffing, which I think is still around. I spent a summer doing, a little telemarketing, a little like fill-in admin. There wasn't anything of Kelly's that I used to do my job. It was just sort of up here and just raw labor. For that kind of thing, I don't think copyright is as important. But for trademark, if you want to build your brand as like, something that people feel good about using your company because it's for a good cause, then, trademark does become important.
Okay.
So I hope that answers your question. If not, ping me offline in the slides. I've got my email, just, ping me. So let's see if we can pick up a few more of these questions. I know we're running over, so I will take the view that whoever's still on, I'm glad to stay for a little bit longer. Whoever's still on, I will keep going. Let's see here. So this is a fun one because I like to do a little bit of content work. Serenavas, the presidential debate broadcasts on TV. Can I translate and release on my Facebook or YouTube? Do I need permission from the original broadcaster? I'll tell you, the answer is very much yes. That's a classic example of if you don't have a license, you can't reproduce it. Now, I'll try to give a real world answer, which is people take snippets all the time and they put it on YouTube and things like that. And, I think that, these content companies, obviously if you go on YouTube, there's all kinds of stuff that's on there. Okay. So I'm not going to sit here and advocate that you break the law or try to tell you something's okay when clearly under copyright law, it's not. That said, yes, do you see a lot of that? Sure. And then it becomes kind of a balancing thing for the content owner. Sometimes the content owner wants a little bit of stuff shared because it helps ultimately drive traffic to their real site, things like that. But that's a classic example where the copyright owner controls the exclusive rights of distribution and public display, and so for someone who's going to put something on YouTube, a short snippet, frankly, I kind of doubt that CBS or CNN or whatever is going to come after you. But, there's people out there, if they try to really monetize it and they try to bring snippets of content from a lot of different content owners, that's when the content owners tend to, really care. So let's see. Let me try to address something that Jessica Lee just wrote in, that I will try to link it in more to licensing versus like straight IP, because the question as it's written is, what is your opinion of getting an international patent on your IP? Well, just remember that IP by definition is very territorial. So a US patent controls the making, using, and selling of a product within the US. So for example, I could have a patent on a paperclip. Let's assume that, this was back when paper clips, maybe binder clip, maybe that's a little better, right? Binder clips are great. They do what paperclip does. They do what a stapler does. A staple does. They're really great. Let's assume that binder clips had just come out. If all I had was a patent on a binder clip in the US, in theory, someone in England could make, use, and sell those binder clips, and I'd be out of luck. And so, because remember, you can only license the rights that you have. So in other words, if I have a license and a US patent for that binder clip, and someone in England says to me, hey, these binder clips are great, I really want to make them, can I get a license? Well, if I don't have rights in England, I've got nothing to license. So I guess that's a long way of saying that keep in mind that, I think this is a question from, oh, I think it's gone already. Maybe it's under the answered pile. You have to get rights in the country if you want to be able to exploit or grant licenses in that country. Now, keep in mind one thing: there is no such thing as an international patent. Patents are country by country. There are some mechanisms in Europe for getting EU patents. There are patent treaties that make it a little easier once a patent has been issued in one country to get a patent in another, but there is technically no such thing as an international patent. So I did want to make that clear. Let's see here. Let's try and take a couple more. Let's see, from Vic Ballara. I tried to use an excerpt from 60 Minutes for training session. They would not allow any licensing of it. Yeah, it kind of depends who you hit. Very bureaucratic. Yeah, I could see that. And, to be honest, this is a good example of where you might have some what's called fair use rights. So fair use is a very big exception to infringement. Fair use does allow for some use of copyrights in limited purposes. There's 4 factors. Training is one of them. Commercialization is another. In other words, if you're using it for internal training, you don't really charge a separate fee to outsiders. That would probably lean towards fair use. So hopefully just keep that in mind for those who are dealing with very limited uses of copyright and they think it's going to be difficult to get a license. Let's see here. There's a question from Anonymous who says, I read a quote online that I like. I translated it and I posted on Instagram or social media. Do I have the writer's permission to translate it? You do not have the writer's permission to translate it unless the writer gave it to you. I know that sounds like a really flip answer, but it's really to address the bigger point, which is people, for whatever reason, think that things that are posted on social media constitute a license to the world. It most definitely does not. So, and to kind of dovetail it back to the advice I gave Vic Ballara, sometimes you have limited rights in content. I can't imagine that translating it would fall under that. But let me take your question and go one step further. I'm going to assume that the writer gave you permission to translate it. Whether you own the copyright in the translation, frankly, will depend on what the permission said. So it's a little bit of a lawyerly answer of it depends. But again, it is something that does come up in real life. People say, oh, I got this right to modify it, therefore I own it. Not necessarily. If you wanted to make sure to own it, make sure in whatever license agreement that you got to get the right of modification, make sure you address that. Let's see here. Hannah, should we take a couple more, or are we just going way too over at this point?
We are starting to lose people. So
Okay.
I
feel like there's so many open questions. So I guess I'll leave it as, I think in the last page, I've got some emails. I'm not going to promise that I could answer every question, but you've got my contact information. Let's see, is there anything, trying to think. How many people do we still have on, Hannah?
About 40.
40. Okay, maybe I'll take just a couple more and then we'll wrap it up. How's that sound?
Yeah, till 110.
Yeah, till 110. What time is it now?
106.
Okay, I'll take a couple more here. Let's see. Let me try and pick a couple of good ones that hopefully a lot of people will care about here. Well, here's one that's kind of interesting at a personal level. Someone, whoever anonymous attendee is, I have a tool built in Excel to automate some engineering analysis. Can I copyright trademark it? How much does it typically cost to do something like this? How long does it take? Well, you copyright it the moment you wrote it. So I'm going to assume that you wrote it in some sort of Excel script language. I think that's what they call it. So when I was a kid, I used to write some software using DB4, for those of you who are old enough. The problem, and so the thing is, for the most part in this country, software languages are not copyrightable. And so when you write new code, the owner of the language, the scripting language, can't claim any copyright in what you wrote, and you do get the copyright right away. I don't think it necessarily makes sense to trademark it, because trademarking is all about like brands. I mean, if you want to try and build a business around, using a flashy name, that's the kind of thing you would trademark, a logo, but the code itself is not trademarked. How much does it cost? Well, it doesn't cost anything to obtain a copyright. If you want to register the copyright, that takes a little bit more, but frankly, 99% of copyrights in software aren't registered anyways. So I hope that answers that. And there were some questions that were really more about trademark registration. So I'm going to not address that. Let's see here. Oh, you know what? I just realized something. Oh no, never mind. CLE code. You know what? I don't think we actually give CLE code for this. It's funny. I didn't even realize there were some other lawyers on here. Ari Bernstein. If you want to contact me afterwards, maybe I can arrange it, but I didn't even really think that there were lawyers on here. And then there was a question from Serinivas. USPTO COVID time comp question above, please. Oh boy, I'm not even sure I'm going to be able to find that. Covina code question. Oh boy, I don't think, oh, here we go. Does USPTO giving or adding this COVID period like the whole of 2020 couldn't use for marketing provisional patent? This is more of a patent prosecution question, a little bit outside my area. Yeah, I understand the USPTO extended some deadlines, kind of like the IRS extended some deadlines for filing this year. So a little bit outside my area. If you want to email me, Srinivas, I can probably put you in touch with a patent prosecutor. So at that point, we've run a little bit over. I want to thank everyone who stuck with it. And I will be able to get the slides out to everyone tomorrow. And, you know, if people want to ping me separately by email to talk about things, glad to take them. And let's see, Hannah, is there anything else I need to do, or should I just sign off?
Well, we both want to thank you so much, Stephen. Hannah and I would like to thank you for your presentation. Clearly, there was a lot of engagement. We have a record number of questions, and Hannah's recorded them all. So I think between all of us, we can hopefully get some of them answered. Yeah. We put your email in the chat, as well as ways to contact the SBDC. So hopefully people can reach out if they didn't get their questions answered. Yeah. And yeah, like Stephen said, everyone will get a recording and slides tomorrow via email. And if you need immediate assistance from any of us, please reach out and contact us. But we're here to help you and your business start, grow, and succeed. So thanks, Stephen, so much for your time today. And thanks to everyone for joining us.
Right. Oh, by the way, Julie, if you don't mind I got to give one lawyerly disclaimer. Everything about Apple and Adobe, that was all completely made up, hypothetical, and none of that was factual. So I do want to put that in there.
Understood. Yeah,
I think people got that, but I just want to make sure.
We'll include that in the recording for sure.
Okay.
Great. Well, thank you so much for your time, and thanks everyone. Have a great day.
Thanks.
Okay. Bye-bye.
Bye.